an agreement, Your Honor.
Okay, Ms. Brenner, is that agreeable with people?
Yes, Your Honor, I'm agreeable at this point because I understand he's just back to work. I do expect to see payments when we come back, or we'll be addressing bond at that time. He's got a pretty high order too, Rhonda, so I don't know if he wants to try to get that modified.
I think he is going to go and request.
I filled out a request form for a 3-year review.
Okay, so you know, sir, when you request a review, that doesn't lock in the date to go back and change it. So what I mean by that is if you file a motion, as of today, they would go back to today and reduce your order. With a review, they don't do that. When it, let's say they review it in 3 months, you'll still have this high order for the next 3 months. Whereas a motion, it would go back in time to the date you filed. So that's fine to do it the way you did it. It just, it has that difference. Okay.
Okay. Thank you very much.
All right. So let's go with July 23rd then at 8:15.
And I would be happy to do the stipulation in order with Ms. Brenner's permission.
Yes, thank you.
All right, so July 23rd at 8:15.
Thank you, Your Honor.
And thank you, Your Honor. Mr. Schiavello, you're all set. You can go ahead and log out.
Thank you, sir.
Okay, Ms. Clark, are you formally known as Bianca McClenny-Vidalez?
Yes.
Okay, Ms. Underwood, do you need a breakout session with her?
I do not. We are ready, Your Honor.
Okay. All right, this is file 25-22160-FH, People versus Bianca McClenny-Vidalez. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner?
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Ms. McClenny-Vidalez, Your Honor.
All right, and where do we stand with the case today, Ms. Underwood?
Ms. McClenny-Vidalez has received secured employment, Your Honor. It's going to be probably taken right out of her check. So we are agreeable to another adjournment or an adjournment in this matter. And I guess that July 23rd, or maybe one time after that, or one date after that, would be fine in this matter, the court.
All right, Ms. Brenner, are the people agreeable with that?
Yes, Your Honor.
Okay, Ms. Brenner, for some reason I don't have an information in this file, so if we could get one, we'll need that. And
I'll get that to you, Judge. Thank you.
okay, go with July 30th then at 8:15.
Thank you, Your Honor. And I'd be happy to do the stip and adjournment again.
Thank you, Rhonda.
Oh, I'm sorry, July 30th won't work, so let's go with that same 23rd date.
Okay.
I'm sorry.
July 30th doesn't work, so let's go with July 23rd.
Okay. Thank you, Your Honor.
Thank you.
Thank you. Have a nice day.
Thanks, you too. All right, Mr. Amadeo, are you ready to proceed with Ms. Flores?
I am, Judge.
Okay, this is file 25-22118-FH People versus Emily Kristen Flores. We are here today for a hearing on an order to show cause, and we are proceeding today by video conference. First, well, I guess we don't need a prosecutor. Mr. Amadeo, you want to place your appearance on the record?
Thank you, Your Honor. William Amadeo, P76194 for Emily Flores, who is seeking my right. Emily, please state your name for the court.
Emily Flores.
All right, Ms. Flores, have you received a copy of the motion affidavit in order to show cause?
Yeah.
And that motion affidavit in order alleges that you violated your bond conditions by testing positive for alcohol on March 25th and May 24th. Do you understand that?
Yes.
Do you understand that the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes.
Mr. Amadeo, do you know how she wants to proceed?
Your Honor, I did speak to Agent Coast yesterday. We're ready to prepare a guilty plea on this. And I did send over a memo to you as well last night when I found out about it. So we're not going to hold a hearing, Judge. She will plead guilty. I'd like to allocate when appropriate.
And I know we had one pending. Had she pled guilty to that also?
Yes.
Okay. Ms. Flores, are you satisfied with Mr. Amadeo and the advice that he's given you?
Yes.
Do you understand that you have a right to contest this contempt of court charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
You do not have to, I'm sorry, you have the right to have all the witnesses against you appear at your trial. You have the right to have the court order any witnesses that you have for your defense to appear at your trial, and you have the right to question those witnesses, or you have your lawyer question those witnesses. Do you understand that? Sorry.
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you anyway. Do you understand that?
Yes.
On the other hand, you have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charges that you violated your bond conditions?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Do you understand, I'm sorry, has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea. Do you understand that?
I understand.
Is it your own choice to plead guilty?
Yes.
So you are aware in this case that you had bond conditions that prevented you from consuming any alcoholic beverages. Is that correct?
Yes.
And you tested positive for, had a positive blood alcohol content on March 25th, 2025 at approximately 6:11 a.m. Is that correct?
Yes.
And had you consumed some alcohol around that time?
Yes.
And on May 24th, 2025 at 6:01 p.m., you also tested positive for alcohol. Is that correct?
Yes.
And had you consumed some alcohol around that time as well?
Yeah.
Okay. I will accept the plea then. It has been given understandably, voluntarily, and accurately. Ms. Flores has had full knowledge of the rights. She has had competent counsel. Mr. Amadeo, is there anything you would like to say before the court passes sentence?
Yes, Your Honor. I did reach out to Agent Ghost yesterday, reviewed everything with him. Emily did admit that she drank. She has been going through some issues with depression and such, but she's really turned her life around. This was a pretty isolated incident. There was 1 or 2 beers that were drank. Agent Ghost did not think there was a lot of alcohol involved. She does have a sentencing coming up on July 3rd. There's an agreement for no upfront jail on that matter. I'd ask that she has more testing, but she did just get a job. We're having another interview, correct?
Yes. That's this evening.
Okay, for Texas Roadhouse?
Yes.
Okay, and I did do a memo last night when I found out about this. I don't think the people are looking for any incarceration here. I know she can't drink, Your Honor, but other than the isolated drinking, she's really doing well in life and has turned things around. So I asked that maybe she be tested more, but I am asking for no incarceration on this. I don't think the people had any objection when I reached out to them.
All right, Ms. Flores, is there anything you'd like to say on your behalf?
I understand I made a very foolish mistake and I apologize to the courts.
All right. So we have sentencing on this on July 3rd of 2025. There's obviously a problem that Ms. Flores has with that. Understand. Something needs to be done to address that problem, because the threat of incarceration has not done the job. Right. We've had prior contempt. I agreed to adjourn the sentencing on that prior contempt and essentially offered to dismiss it if she was able to not consume alcohol between the date of the last hearing and the sentencing. So there's an issue here that needs to be addressed.
And for what it's worth, Your Honor, I did tell her if you were willing to hold us in the bank until July 3rd, she didn't test positive since then, that would go a long way towards showing she respects the potential deal in place. I do understand she dropped the ball a few times. I did take over this file a few weeks ago, and I am trying to play a role to make sure her life gets turned around, Judge. I think I'm the fourth lawyer because there's been some conflicts, but I don't want her drinking. I want her to have a good life. She really has tried to turn her life around in a lot of ways, Your Honor. There's clearly an issue here, but I do think that she has a chance to be a very productive individual, so I'm asking you to give her that chance.
So I want those things too, but I need action from your side, Ms. Flores. I would also say that given the contempt since the plea, the court's not obligated to follow the sentencing agreement.
I'm aware, Your Honor.
What I'm willing to do at this time is adjourn the sentencing on this contempt again to the July 3rd, 2025 date. I am going to modify the bond conditions so that Ms. Flores needs to have a SCRAM unit in place so that she's monitored 24/7. And a large consideration when we get to the sentencing hearing is what has been done between now and the sentencing hearing in order to address alcohol use. It's in some kind of, if Ms. Flores are in some kind of treatment, it's going to go a long way in determining what I decide. Nothing has happened. That would also go a long way in deciding what to do. So I'm giving you a chance, but this is about the last chance to address the issue with alcohol. It's time to do something. Because if it continues, I've got to do something else. And,
So, Judge,
and that's
part of the bond conditions, then, is that going to include the counseling?
yes.
Okay.
So you're going to need to work with Mr. Coast to find some form of counseling. I'm not going to tell you what it needs, what it is, but you're going to need to work with him to find something.
Agent Coast, do you want her coming to you today, or I don't have to
Yes,
scan?
yes, I'm going to need to see her today, so we could switch the remote breath over to the SCRAM unit. Emily, you just need to come to the courthouse, come up to the 3rd floor, go across the hall to the clerk's office, let them know that you're there to see me. You could do that this morning or this afternoon between 1:30 and 3.
I'm going to send her up after our hearing, Agent Coast, so that's okay.
Very good.
Yeah, she's in the courtroom now, Mr. Coast.
Oh, okay. Gotcha. Yep, I'll see her now then.
Okay, so he'll probably just meet you in the hallway. All right, so we'll be back on, what was it, July 3rd for sentencing.
15, thank you.
Okay, thank you. We're all set for this case.
Yes, case.
And who was your other case, Mr. Young?
Mr. Pinkle, he's on Zoom, Judge.
All right, Mr. Pinkelman, if you're there and can hear me, I need you to unmute your device.
I'm here.
Okay.
Okay.
All right, this is file 25-22212-FH, People versus Brent Stephen Pinkelman. We're here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, may I have the people?
Good morning, Your Honor. William Amadeo, P76194. We have Brent Pinkelman. Mr. Pinkelman appears via Zoom, consents to such, and thanks for allowing the Zoom. Brent, please state the name for the court and the prosecutor that is you on Zoom.
Brent Pinkelman.
Okay, Mr. Amadeo, where do we stand with Mr. Pinkelman's case today?
Yeah, there are a few pieces of discovery I need to review with the people to discuss potential plea negotiations. I did speak to Prosecutor Wise briefly about this. I know we both have a lot of trials this summer. I'm going to ask for a 45-day adjournment to set out our pre-trial to see where we stand. And at that point, we may have to set a trial depending on where we are. But I did want to take one crack at trying to resolve it. And I did speak to her a couple of days about that. I won't speak for Prosecutor McClure, but I don't think Ms. Wise had any issue with that.
Judge, Ms. Wise has no issue with that. She just wanted to double check if there was going to be a forensic ordered in this case, and if so, we'd like to get that done before the next adjournment.
I guess that's the concern that I have with it. There was a competency evaluation ordered back on November 14th of 2024. And I don't have anything in the file showing that that was resolved before the bind over was waived. And
I can explain that, Judge.
okay,
I filed a forensic initially. I felt he may have been warranted for one. And forensic center never got back to me. Then I met with Brent a few more times. At that juncture, I thought it would have been a waste of time to do the forensic. He seemed competent. So I did tell the forensic center, I don't feel I need one at this time. I did tell Prosecutor Wise, I didn't want to file a frivolous forensic. But when I first took over the case, I felt it may have been warranted in continually speaking with Brent. I didn't think he'd come back non-competent, so I kind of pulled it. I did call the forensic center, they never got back to me, but that's where we stand. For the record, I do think he's competent to move forward, so I don't think he needs a forensic. That was my first impression of the matter. After continuing to meet with Brent, I do feel he's competent and it wasn't warranted.
okay. And I'm sorry, did you say 45 days?
45 possible, Judge. I'll do a stip if that's acceptable.
Let's go with July 16th then at 8:15.
Thank you.
Is there anything else we need to address with Mr. Pinkelman's case today?
Not from the defense, Your Honor. Thank you.
No, thank you.
Okay, thank you. Mr. Pinkelman, you can go ahead and log out.
Thank you, Your Honor. Have a good day.
Thank you. Mr. Glazier, are you ready to proceed with Mr. Shears?
Yes, I am, Your Honor.
Okay, Mr. Shears, you want to come forward?
Your Honor,
He's
Ms.
asking for,
Arnold,
Sorry,
I'm
Judge.
sorry.
Ms. Arnold had asked for the court to wait for her to be done and Judge Anselm to do Mr. Shears on her own.
okay, he had asked for a breakout session also. So Mr. Glazier, do you want to speak to Mr. Shears in a breakout session?
Yeah, I can do that, Your Honor.
Okay. All right, Mr. Shears, can you hear me?
Yes, I hear you.
Okay, I'm gonna send you a request to start the video also.
Okay, thank you.
All right, and then I'll put you in a breakout session with Mr. Glazier.
Thank you.
Then I'll fill in that agency information. I'll send it to that agency. I'll just allow them permission to interact with me. Okay. Go ahead and sign there. Date. Oh, sorry. Yeah. So if you want to think.
Okay, Mr. Lyons, is that Mr. Reyna with you?
Yes, Your Honor.
Okay, this is file 25-22213-FH People versus Joshua Joseph Reyna. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, Math the People.
I may please the court, George Lyons, on behalf of the defendant, Mr. Reyna.
All right, and Mr. Lyons, where do we stand with Mr. Reyna's case today?
Your Honor, I forwarded to the court a signed plea agreement and signed rights for Mr. Reyna.
Okay, 1 second, find that. Okay, so I do have that now. So Mr. Lyons, you want to place your understanding of the plea agreement on the record? I'll ask Ms. McClure to confirm.
Your Honor, in my understanding, my client will be determined to be guilty pleas as charged to count 1, a plea in alluding 4th degree, and count 2, possession of an analog. In return, the people will dismiss counts 3 and 4 at the time of sentencing, and they have no objection to H/TA sentencing as long as he is otherwise eligible.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
Mr. Reyna, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Okay, thank you. And you are Joshua Joseph Reyna, is that correct?
Yes.
I need you to speak louder than that. I'm having a hard time hearing you.
Yes.
Tell you what, fix it. How you do it.
And you could, okay, Mr. Reyna, you've heard the statement of your attorney and the prosecuting attorney. So your intention to plead guilty today to count 1, 4th degree fleeing a police officer.
Yes.
I can't hear you.
Yes.
There you go.
Okay. And you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine.
Yes.
Is it also your intention to plead guilty today to count 2, possession of analogs?
Yes.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Mr. Lyons and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That's correct.
Mr. Lyons?
It's correct, Your Honor.
Is that also your understanding, Mr. Reyna?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Reyna, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand.
I'm sorry, I couldn't hear you.
I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
I understand.
Sorry, I can't hear you.
Go ahead to your mouth.
I understand.
Okay. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, or do you have any questions about any of those rights?
No.
And do you understand that you're giving those rights up?
I understand.
How do you wish to plead to the charge that on or about November 10, 2024 in the city of Hudson, County, Illinois, state of Michigan, that you did commit the offense of 4th degree fleeing a police officer?
Guilty.
And how do you wish to plead to the charge that on or about November 10, 2024 in the city of Hudson, County, Illinois, state of Michigan, that you did commit the offense of possession of analogs?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
I'm sorry, I couldn't hear you.
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Understand.
I need you to speak louder, sir.
I understand.
Is the prosecutor defense counsel aware of any promises, threats, or inducements to, other than the plea bargain, to induce Mr. Reyna to plead guilty today?
No, Your Honor.
None, Judge. Thank you.
Mr. Reyna, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here today?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that, Mr. Reyna?
Can you repeat that?
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating your bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I understand.
Is it your own choice to plead guilty today?
Yes.
Mr. Lyons, do you want to cover the factual basis?
Your Honor. Mr. Reyna, on or about the 10th of November, 2024, were you operating a motor vehicle in the county of Lenawee, city of Hudson, state of Michigan?
Yes.
And on that day,
I need Mr. Reyna, I need you to speak louder and more directly into the microphone. I've got to be able to get an adequate recording of your voice.
Yes.
and on that day, while you were operating that motor vehicle, did an officer in a fully marked police vehicle attempt to stop you?
Yes.
And did you increase your speed and otherwise attempt to flee and elude the officer?
Yes.
On that same day, once you were stopped, did you have in your possession analog oxycodone?
Yes.
You knew and understood what it was, and you did not have a prescription for it. Is that correct,
Yes.
Your Honor?
Ms. McClure, are the people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Lyons?
Court has, thank you.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Reyna has had full knowledge of his rights and has had competent counsel. The court has not made any agreement regarding possible plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here today. I'm going to refer this matter to the probation department for pre-sentence investigation and set sentencing for July 10th at 8:15 a.m.
Would the court allow us to do it via Zoom or in person?
Give me 1 second.
Not a problem, Judge.
We can do that by Zoom.
Thank you, Your Honor.
Okay, Mr. Reyna, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background. I'm going to put you in a breakout session with Mr. Moore from the probation department so he can collect Mr. Reyna's contact information and give him some instructions on what's going to happen next.
Not a problem. Thank you, Judge. I'll wait right here.
Okay, Ms. Aycock, is that Mr. Forbes Lavat with you?
Good morning, Your Honor. Yes, this is the defendant present to my right.
Okay. All right, so this is file 25-22219-FH, People of the State of Michigan versus Jacob Valentino Forbes Levant. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Good morning, Your Honor. For the record, Leslie Aycock on behalf of Mr. Forbes Lovett, who is present to my right. Can you please state your name for the court this morning?
Jacob Forbes Lovett.
Okay, and Ms. Aycock, where do we stand with your client's case today?
Your Honor, Ms. McClure and I have had some ongoing discussions. I believe that we are requesting an adjournment of today's pretrial to continue negotiation.
All right, Ms. McClure, anything we need to address from the people's side?
No, I would agree with that.
Okay. Let's go with June 25th at 8:15 a.m. if that works.
Would that be by Zoom, Your Honor?
Yes.
Then that would be fine. Thank you.
And our office can do that step in order to adjourn. What was the date? June
25th.
Miss Aycock, can I sign that with your permission, or would you like to sign that?
You may sign with my permission. Thank you.
Okay, is there anything else we need to address with the case today?
Nothing from the defense.
No, thank you.
Okay, thank you. Then I think we're all set, and you can go ahead and log out.
Thank you, Your Honor. Take care.
You call for Mr. King.
I like in judgment makers. Could we have Derek King and you invite?
Okay, let's see, Mr. Glazier, are you ready to proceed with Mr. Shears?
Yes, I am, Your Honor.
Okay, we do have Ms. Arnold now, so Shears, you come forward. This is file 24-21752-FH and 25-22116-FH. People versus Frederick Will Shears. We are here today for a pretrial conference in both of those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazier on behalf of Mr. Shears.
Okay, and where do we stand with Mr. Shears' cases today?
Your Honor, we just got assigned these cases. I forget who his attorney was. He had an attorney on these, and they just got reassigned to us, so we need some time. I'd ask to have a pretrial about 90 days away. I got a transcript. I don't know if it's the transcript for both files. I have some search warrants, but I don't have any police reports at this time. So we need to have some time to prepare and then maybe file some motions.
Okay, Ms. Arnold, anything we need to address from the people's side?
I know Mr. Shears isn't in custody. That seems like a long period of time, but whatever the court wants to do. One of the things I wanted to bring to the court and Mr. Glazier's attention is when Mr. Lyons was on the case, we filed a 404B notice, and he was going to file a motion to object to that 404B evidence. We need to resolve the issue about whether that evidence comes in or not, because I was going to seek to consolidate the cases for trial. which I think makes sense if that evidence is coming in anyways. So Mr. Lyons wanted to file the objection to that. I think it makes sense for defense to file that motion because under 404B, if we don't know the nature, knowing the nature of their defense helps the court decide the motion, and that can be addressed in a motion objecting to our notice. So if Mr. Glazier doesn't want to file a motion to object, I will file a motion in limine. But I just wanted to clarify that so we know how we're going to resolve that particular issue.
I don't even have
Unless,
the
of course, they don't
404
object to it at all.
I don't even have the 404B notice, so this is all news to me at this point.
Maybe we should do a quicker pretrial and Mr. Glazier can let us know what, because I don't know if the court wants to set some motion deadlines. I'd like to know if I need to file a motion or if they're going to file that motion, so we can figure out the consolidation issue. I'm not sure the best way to accomplish that.
All right, what I'm going to do is set it for a pretrial on August 6th at 8:15 a.m. And the thing would be helpful, maybe Ms. Arnold, Ms. Glazier, if you can get together and maybe walk through that yourselves a little bit, and then one side or the other can make a decision on what's going to happen with respect to getting that issue before the court. But it does sound like
if Ms. Arnold would serve me the 404B notice, I don't even have that.
Well, it was served on Mr. Lyons, so I don't want there to be an inference that we didn't follow appropriate procedure.
I'm not inferring that at all, but I'm not Mr. Lyons, and I've never been served this 404B since I've taken over the cases.
Mr. Lyons given you the discovery and the other paperwork?
Nope.
Well, it's well, I mean, Judge, we can resend it, but I think the obligation on defense is to get that from prior defense counsel, but we'll resend everything.
I don't know if Mr. Lyons has any obligation to do that or not, Your Honor. I know you let him off the case and you put me on it. That's all I know.
all right. Well, so August 6th at 8:15 a.m. Ms. Arnold, appreciate you if you would send that over. Otherwise, it's in the court's file.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Your Honor,
yeah,
he was supposed to ask something.
Oh, I forgot. Your Honor, Mr. Shears is on a tether. I think is it for drugs, Fred, or alcohol, or what?
Drops.
Oh, drops. Excuse me. I was thinking he has drops, and he's been 3 or 4 months now and has never tested positive. He wondered if he could be taken off that at this point in time.
Sir, I'm sorry, Ms. Arnold, do the people have any position on that request?
I think he did test positive in district court, I believe. I guess
Mr.
I think we
Coast,
should hear from
no.
Mr. Coast on it.
Yeah, Judge, I am having him test 2 times a week. He's done a very good job. He either tests negative or ETG, which is alcohol. But as part of his bond conditions, he does not have a no alcohol clause. I wouldn't be opposed to him switching over to teal, which he tests 1 time a week. But no, he's done a good job testing. I think I added it up, and he's up over 30 tests.
Okay.
Right,
All
with
right,
that-
so at this point, I will agree with Mr. Coast that moving Mr. Shears to 1 time per week seems appropriate, so I will do that.
Thank you.
Hey,
Okay,
Freddie,
anything else?
I'm gonna need to see you so I could switch cards for you, because you're gonna switch colors.
Okay,
So if I could just meet you out in the hallway.
yes, sir. All right, so I think we're all set for you.
Thank you, Your Honor.
Thanks, Judge.
Okay, and let's see. Mr. Mawad, are you ready to proceed with Mr. Ziflo?
I am, Judge, and then Brian Merritt's the other case. He is just now going to be getting on. He did not have the Zoom information, so Brian Merritt will be getting on, but we are going to be doing the Zitlo matter right now.
Okay. Ms. Unwood, you need to talk to Mr. King.
No, I do not, Your Honor.
All right, we'll get to that one in just a second. All right, Mr. Zitlo, if you're there, I need you to unmute your device.
Yes, sir.
And I'm going to send a request to start your video. Okay.
Okay.
All right, so this is file 22-21153-FC, People versus Travis Allen Zitlo. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure on behalf of the people.
Your Honor, Elias Fuad appearing on behalf of Travis Zitlo, and I also will note my paralegal who worked very hard on the case, Ashley, is on also.
All right, and where do we stand with the case today, Mr. Mawad?
Judge, we have entered into a plea agreement, and the plea agreement is as follows. My client for civil liability will plead no contest to count 5 CSC 4th degree. It's a sentence of probation and no initial incarceration to be imposed. All the other counts would be dismissed. The additional terms would be there'd be an allowance for supervised contact with the non-victim minor child, which is Mr. Zitlo's blood child, and with the initials of EZ while on probation. Otherwise, there would be no contact with anyone under the age of 16. This conviction, and Mr. Zitlo knows this, will result in a lifetime registration under the Michigan Sex Offender Registration Act. And I believe that that is the terms of the agreement.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
Your Honor, yes, and I did send the plea agreement to Mr. Mawad yesterday, so I just would ask that a signed copy of that be forwarded to the court and our office. It can be after the plea is fine.
I think we sent it to you about 10, 15 minutes ago. Phoebe, did you get it?
Well, I haven't
You-
checked my email, I guess. So.
Okay. I hope
Yeah.
the court got it. We sent it to the court's clerk too, Madam Clerk.
The only deviation from what Mr. Fawad said is just a clarification that the sentence of no initial incarceration, I put that on the plea form as a sentence recommendation so as to not preclude the victim from coming in and asking for what she wants to ask for. But just knowing like we are recommending no initial incarceration as this is a G grid offense that is not likely to carry any incarceration. In addition, Mr. Zietlow has been on bond for a couple of years now and has not had any issues. So we know that it's not likely to have any sort of sentence be imposed. But I didn't want to outright preclude the victim from asking for what she wants to ask for.
Okay, I am not finding an amended information with the count 5 on it. Has that been filed already?
Yes, Your Honor, I filed it yesterday morning.
And I did receive it. Phoebe, sorry, I was in Clare County all day yesterday, so I did not get this back to you till this morning, but there is an amended one. Let's see if we can forward it. Do you want to forward it to the judge? If you can, Phoebe, you'll do better than I will.
Sure, yeah.
I think we
It
may
has been
have it.
filed. Miss Aranda did note that she put it in the file, so.
Okay. All right, I've got a copy of that now, and then I would also need a signed advice of rights form from Mr. Zietlow in accordance with the revised court rule. Have we had that?
We haven't, Judge. If you would allow us to get that done after the plea, we'll get it done right away, is what I'm trying to say. I forgot about the new rule with the advice of rights, but we'll get that to the court right away.
Okay, so I've just dropped the advice of rights form into the chat. Mr. Zietlow, are you able to see that?
I'm checking right now.
Boy, better than me, Judge. That's good.
It is loading. Give me 1 second.
Okay.
Okay, I do see it.
Okay. So just take a minute to read that over, and when you're comfortable with it, just let me know when you're done.
Okay, 1 second. I apologize.
Go ahead.
Okay, I read it over. I understand it.
Okay. All right, would you raise your right hand then? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Travis Allen Zietlow.
Zetlow, but yes, sir.
Okay. Mr. Zetlow, you've heard the statement of your attorney and the prosecuting attorney is that your intention to plead guilty, I'm sorry, no contest today to count 5, criminal sexual conduct, 4th degree.
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $500 fine?
I do.
And do you understand that that conviction would require lifetime electronic monitoring?
No, sir. That was not discussed.
Travis, we've discussed that on a number of occasions. It's a lifetime electronic monitoring.
You told me it was absolutely not. In
No.
your office. Yes.
I think we're talking about SORA. It's not, it should not be a lifetime electronic monitoring.
Correct.
Oh, I'm sorry. Yeah, so I misspoke. It requires.
Sorry, Travis, we're getting the two mixed up. You're right.
Yeah, that was my mistake, sir.
You're 100% right, Travis.
Okay.
Do you understand that it requires registration under the Michigan Sex Offender Registration Act?
Which is the SORA, correct?
Correct.
Yes, sir.
And that is a lifetime requirement.
Understood.
Okay. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That's correct.
Sir Mawad?
That is correct, Judge.
Is that also your understanding, Mr. Zetlow?
As far as I understand it, yes.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand.
Okay.
You have the right to speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Zetlow, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I do.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I do not.
Do you understand that you're giving them up?
I do.
How do you wish to plead to the charge that on or about May 1, 2021 to December 1, 2021, in the village of Britain, County of Illinois, State of Michigan, that you did commit the offense of 4th degree criminal sexual conduct?
It would be no contest.
Yes, sir. No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge?
No, sir.
Do you understand that if I accept the plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
I do, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Zetlow to plead no contest?
None, Your Honor.
None, Your Honor.
Mr. Zetlow, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending your sentencing hearing. Do you understand that?
Yes, sir.
Is it your own choice to plead no contest today?
It is.
Mr. Mawad, do you want to cover the factual basis?
Judge, we're going to agree to some facts because it's a no contest plea. You want to do it, or do you want me to do it?
Feel free.
Okay, so I think what we're agreeing to, Judge, and the prosecutor will obviously let me know if there's anything else that needs to be added. Between May 1st of 2021 and December 1st of 2021 in the village of Britton in Lenawee County, Mr. Zietlow did engage in sexual contact with another person, to wit, the person was with the initial NZ. The sexual contact was either to the chest area of the female with the initial NZ or to the buttocks area, and that the defendant, Mr. Zietlow, and NZ were related by blood or affinity to the third degree, if that satisfies the Ms. McClure.
I would just ask for two stipulations. One, that the defendant in this case was the victim's biological father, and that these facts were established at preliminary examination on, excuse me, I have to check the date, on November 22nd, 2022, when it was bound over to the circuit court.
So stipulated, Judge. The assistant prosecutor is correct. All of the elements would be in the preliminary exam transcript.
All right, so I just noticed Mr. Zietlow seemed to be shaking his head during the recitation of the facts. Mr. Zietlow, I just want to confirm that you want to
I'm
proceed
okay.
with-
I'm just upset by this, Your Honor. I'm okay.
Okay, and you understand all of your rights?
Yes, this is just very upsetting. I'm sorry.
Okay, no problem. I just, I'm here to make sure that.
No, I appreciate it. I do.
Okay.
And Mr. Zietlow, you understand, in order to us for a no contest plea, we had to go into that realm. You
I
understand
do.
that?
I
Okay,
do. Just
all right.
hearing it is.
No, I
very-
appreciate you. I appreciate you. You've been a great client. Thank you.
Okay. Has the court then complied with MCR 6.302 B, C, and D, Ms. McClure?
Yes.
Mr.
You
Mawad?
have, Judge.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Zietlow has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 11 at 8:15 a.m.
Judge, I want to tell Mr. Zietlow, if that's okay, if you're going to be meeting with, I believe, Mr. Moore, if you could correct me, with Mr. Jones, right? Who's still handling the CSE cases?
That's correct.
Okay, and Mr. Jones, or Mr. Chris is a good guy. He's going to have you sign up for SORA. We've got to do all that. Obviously, we can talk about that, but he's going to go through everything with you and go from there. Okay?
Okay.
All right.
And for the record, I sent a copy of the amended information in the plea form to Mr. Jones.
All right, so Mr. Zettel, I'm going to put you in a breakout session with Mr. Moore from the probation department. He's going to collect your contact information and give you some instructions about what to do next.
Okay.
Mr. Mwad, do you want to be a part of that breakout room?
Yeah, Mr. Zietlow is upset, and I want to make sure that he's okay. But that'd be great if I can go in, and Ashley too, if that's okay, Judge. If you can bring her in.
Oh, yeah. Yeah, let me give me 1 second here.
And then I'll be back on merit, Judge.
Okay. And Mr. Zietlow, you can log out of the meeting when you finish speaking to Mr. Moore.
Okay.
Okay, Ms. Underwood, are you ready to proceed with Mr. King?
Yes, Your Honor. Thank you.
Okay. This is file 23-21419-FH and 25-22260-FH. People versus Derek Eugene King. We're here today for a pretrial hearing. In both of those cases, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.V. McClure, I'm at the people for 522260.
The other one, I believe, is a probation violation, Your Honor. Your Honor, as we mentioned at the last hearing, we did apply immediately for screening for Mr. King for recovery court, Your Honor. It's my understanding they're meeting on that regarding Mr. King on the 5th of June, Your Honor. So I would ask for a quick court date after that, and I'm more than willing to do the stipulation with Ms. Moore's permission, with Ms. McClure's permission.
You said June 6th they're meeting?
I'm sorry?
What date did you say they're meeting for the screening?
They're meeting on Mr. King on June 5th, Your Honor.
Okay, my next available date after that is June 18th.
Thank you, Your Honor.
So yeah, if you'll do that stipulation in order, please.
I will do the stip in order with Ms. McClure's permission.
No objection.
Okay, thank you then, Mr. King. You can let the officer with you know that you're done with court for today.
Thank you. Thank you.
People for Jonathan Henderson.
Your Honor, do we have Mr. Hill or Mr. Drennan?
Mr. Drennan, you want to come forward and sit at the table here closer to the television, please?
Hi, it's Kevin. Good work, John. Thank you.
Okay, this is file 21-20300-FH. People versus Joshua David Drennan. We are here today on a request and summons for probation violation. We are proceeding today partially by video conference and partially in person. Sir, you are Joshua David Drennan?
Yes, sir.
Mr. Drennan, you're before the court today on an order to show cause regarding an alleged probation violation. Have you received a copy of that request and summons for probation violation?
I did, Your Honor.
That request and summons for probation violation alleges that you violated the terms of your probation by failing to pay fines, costs, and restitution. Do you understand that?
I do, Your Honor.
Do you understand that you have previously, in this case, pled guilty to larceny in a building?
Yes, sir.
And do you understand that maximum possible punishment for larceny in a building is up to 4 years in prison and or a $5,000 fine?
Yes, sir.
And you have the right to be represented by an attorney at this hearing and any other proceedings that we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes, sir.
You want to be represented by an attorney?
Yes, sir.
You have the ability to pay for your own
I
attorney.
do not.
All right. Ms. Underwood, do you want to place your appearance on the record?
I'm sorry.
You want to place your appearance on the record?
Rhonda Underwood for Mr. Drennan this morning, then, Your Honor.
All right. And do you know how Mr. Drennan would like to proceed today, or do you need to speak to him?
No, I believe I was just appointed on this, so it was a show cause,
Okay.
so.
All right,
I,
Mr. Drennan, if you want to step out to the hallway, Mr. Drennan, there's an iPad out there, and I will put you in a breakout room with Ms. Underwood. Okay, Mr. Drennan, I'm going to send you a request to unmute. And need to unmute that device. So if you tap on the screen, you should see a microphone with a red slash through it, and tap on that, that'll turn on the microphone. Okay, I'm going to put you in a breakout room with Ms. Underwood.
Okay.
Can you call the public defender's office and have something? Mr. Murphy, do you need to speak to Mr. Henderson?
Echo, please, Your Honor.
All right, 1 second.
Is it we can get Mr. Bishop if I comes in? John. All right, thank you. Bye.
Mr. Brandt, are you ready to proceed with Ms. Burciaga?
Yes, Your Honor.
Okay, Mr. Stover, as soon as Mr. Glazer gets logged in, we'll hear your case.
Good morning, thank you.
Okay, this is file 25-22115-F8 People versus Cabrina Burciaga. We are here today for a pretrial conference in the case, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Alfred Brand on behalf of the defendant.
Okay, and Mr. Brandt, where do we stand with Ms. Burciaga's case today?
Thank you, Your Honor. Your Honor, as the court can see from the court file, we were retained in the middle of the file. Madam Prosecutor was nice enough to give me the affidavit for the search warrant. I've had a chance to review that. I have some plans relative to that. The last time we were here, however, the co-defendant had Mr. Lyons as a retained attorney, and Mr. Lyons and I had had some discussions. They had a parting of the ways. I do not know if, I believe it's Mr. Shears, if he has retained new counsel or not. So before I start filing paperwork, I need to know who his.
I represent Mr. Shears. Did you say Shears?
Yes. Is that yours, John?
Yeah, I've got both files.
Okay. So if we could have another pretrial date so I could talk to Mr. Glazier and explain to him my thoughts relative to the search warrant, because I think it affects both our clients.
Yeah, I've just got I've just got some of the paperwork. I don't even have the police report yet. I have the search warrants and I have I think that's it, search warrants at this point.
So
And
the whole-
just so Mr. Glazier knows, my legal assistant told me the PD's office was originally on this file, so she believes they originally got the police reports. We also sent all discovery to the PD's office on May 23rd of 2025, but we are going to resend it not once, but twice to make sure they've got it 4 times. So there should be no confusion that they have everything.
And then, Your Honor, in conclusion, Ms. Arnold has made an offer. That offer, if accepted, does affect Mr. Glazier's client. So it would behoove us to let him get up to speed on that issue as well.
Okay, so let me set that for the same date as Mr. Shear's case so that we can keep them together. That was August 6th at 8:15. And Mr. Brandt, would you be willing to do a stipulation in order for that adjournment?
I can do that, Your Honor, and it may very well be that at least my case will be resolved before that date. If in fact that happens, we will let Ms. Arnold and I will let the court know, and we can do the plea before.
Yeah, you're welcome to call and get an earlier date if you'd like.
And Mr. Brandt, you can sign my name to that stipulation.
Thank you so much.
Thanks.
Okay, anything else, Mr. Brandt, that we need to discuss with that case today?
No, Your Honor, thank you.
No, thank you.
Okay, all right, Ms. Burciaga, then you can go ahead and log out.
Thank you. Have a good day.
Thank you. Mr. Glazier, do you need a breakout session with Mr. Stover?
Your Honor, I think this is I had a violation of probation. I think it got dismissed. Is this a new one?
Yes, there were 2. One got dismissed and one is related to some new charges or new whatever the issue was in Macomb County.
Okay. Yeah, let me, well, I don't have a copy of that, I don't believe.
I'm fairly certain you do.
Well, it hasn't made it to, we don't even have a file on them. We'd closed out the other one. What's the allegation, Yana? Can you tell me that?
There are 3. There are two technical that he failed to report to probation since March 14th, and that he failed to pay anything toward his fines and costs. And one non-technical that he was charged and convicted on March 31st, 2025 of third-degree fleeing a police officer and resisting and obstructing.
Okay. All right. Yeah, let me speak with him, Your Honor.
Okay, let's see. Ms. Underwood, are you ready to proceed with Mr. Drennan?
Yes, thank you, Your Honor.
All right, we're back on the record in People versus Joshua David Drennan. Ms. Underwood, do you know how Mr. Drennan wishes to proceed today?
Your Honor, we're going to ask the court to enter a not guilty plea on Mr. Drennan's behalf and set this out for maybe 3 weeks, Your Honor, to see whether Mr. Drennan can change his circumstances such that he can make inroads into the payments on this, Your Honor.
Okay, I'll set it for June 18th at 8:15 a.m. Mr. Drennan, you can appear by coming to court in person like you did today, or you can attend by Zoom, and the bailiff has our Zoom information. Thank you. Thank you. Mr. Murphy, are you ready to proceed with Mr. Henderson?
Yes, Your Honor.
This is file 24-22020-FH and 24-22021-FH, People versus Jonathan Craig Henderson. We are here today for pretrial conferences in both of those cases. There are also 3 pending contempt of courts in each of those cases. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.V. McClure, map the people.
Matthew Murphy, appearing behalf of Mr. Henderson.
And Mr. Murphy, where do we stand with Mr. Henderson's cases today?
Your Honor, from my understanding, the offer from the prosecution would be for Mr. Henderson to plead to 1 count on 1 file, 1 count of possession of methamphetamine, dismiss the other file with no further agreement for sentencing. Again, if that's still the offer, for him to plead to 1 and dismiss the other file with no habituals on that plea, he does wish to accept that at this time. In regards to the contempts, he wants to take responsibility. I don't know if the court wanted to enter a plea today or if the court wanted to do that at the date of sentencing, but again, he'll take responsibility for the contempt for failing to appear as well.
Okay, Ms. McClure, is that a complete and accurate statement of the plea?
It is.
All right, and does it matter which file he pleads in?
Your Honor, I believe the understanding was the first file, but there wasn't an agreement to either one. So, Ms. McClure, if they had a preference, either way, but if not, we'll just do the older file.
Yeah, typically we do whatever the first one was.
Okay. Mr. Henderson, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do, Your Honor.
And you are Jonathan Craig Henderson?
Yes, sir.
You can put your hand down if you want. You have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 24-22020 to count 1, possession of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Henderson?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Drennan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
And I apologize, I called you by the wrong name, Mr. Henderson.
That's okay.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about May 15, 2024 in the city of Adrian, County, Illinois, state of Michigan, that you did commit the offense of possession of methamphetamine?
Guilty, Your Honor.
Has anyone made any threats or promises to you in order to get you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Henderson to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Henderson, has your attorney promised you any particular sentence or estimated what your sentence would be?
Not really. Yeah, he has possibly like a few more weeks out, and other than that, no,
Okay.
not really.
Your Honor, I told Mr. Henderson that there'll be a few weeks, 6 weeks or so before sentencing. At that point, I would ask the court to consider credit for time served, but the sentencing guidelines are applicable, and ultimately it's up to the court to decide per those guidelines what will be the appropriate sentence.
Okay. Do you understand, Mr. Henderson, that regardless of any conversations you've had with Mr. Murphy, ultimately it's the court's job to decide what the sentence is, and that could be the same as what he's told you, could be different than what he's told you?
Yes, Your Honor.
And you want to continue with your plea?
Yes, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Mr. Murphy, do you want to establish a factual basis?
Yes, Your Honor, I can. Mr. Henderson, were you indeed in the city of Adrian, the county of Lenawee, state of Michigan on May 15th of 2024?
Yes, Your Honor.
You don't have to, I'm not judging, to call me Your Honor, just a yes or no. Okay, and on that date, did you have in your possession methamphetamine?
Yes,
And did you know that it was methamphetamine?
yes, it did.
Okay, and was that for your own personal recreational use?
Yes.
Okay, Your Honor, I believe we satisfied the factual basis.
What? Yeah.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor, thank you.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Henderson has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 11th at 8:15 a.m. Mr. Henderson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes, Your Honor.
All right, we are all set then, Mr. Henderson. You can let the officer with you know that you're done with court. Oh, I'm sorry. I apologize. I forgot to do the contempt. So a few more questions for you, Mr. Henderson. You understand the maximum possible penalty for the contempts is up to 93 days in jail or up to $7,500 in fines.
Yes, Your Honor.
And do you understand you have the right to contest those contempt of court charges, have trials on those as well?
Yes, Your Honor.
And do you understand that throughout that trial, you'd also be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
And you understand that throughout that trial, you'd have all the same rights that I already explained to you prior to pleading guilty to the underlying charge?
Yes, Your Honor.
And that would include the right to have the witnesses against you appear at your trial, to ask questions, to testify or not testify. Do you understand all that?
Yes, Your Honor.
And how do you want to plead to the charge that you violated bond conditions by failing to do drug testing on October 3rd of 2024?
Guilty.
And how do you want to plead to the charge that you violated your bond conditions by failing to appear in court on December 4, 2024?
Guilty.
And how do you want to plead to the charge that you violated bond conditions by failing to appear on March 12, 2025?
Guilty.
Okay, so you were aware that you had bond conditions in this case that required you to do drug testing, is that correct?
Yes, Your Honor.
And you were required to test on October 3rd of 2024, is that correct?
Yes, Your Honor.
And actually, I think I misspoke. You actually did test and you tested positive on that date, is that right?
Yes, Your Honor.
And you also had a bond condition that required you not to use any controlled substances, is that correct?
Yes, Your Honor.
You're also required to appear in court for all court hearings, is that right?
Yes.
And did you fail to appear on December 4th, 2024, and then again on March 12th, 2025?
Yes, Your Honor.
Okay, I'll accept those pleas. They've been given understandably, voluntarily, and accurately. Mr. Henderson has had full knowledge of his rights. He's had competent counsel, and I will set sentencing for the same date as sentencing on the underlying charge.
Thank you, Your Honor.
Okay, so now you're all set, Mr. Henderson. You can let the officer with you know that you're done with work.
Thank you.
Thank you, Mr. Henderson. I'll talk to you soon, okay?
All right, later, Matt.
Okay, Mr. Glazier, are you ready to proceed with Mr. Henderson?
Mr. Henderson?
Sorry, I can't keep names straight this morning. Mr. Stover.
Yeah, yes, Your Honor.
Okay. This is file 21-20605-FC, People versus John Mitchell Stover. We're here today for a probation violation. See. Guest and arraignment. We are proceeding today by video conference. Sir, you're John Mitchell Stover?
Yes, Your Honor, I am.
Mr. Stover, have you received a copy of the request and warrant for probation violation that's dated April 4th, 2025?
I do not have any paperwork, Your Honor.
I'm sorry, I misspoke. I signed that on April 25th, 2025.
Yeah, I apologize to inform you I have no paperwork.